Yeah, I'll try to be brief. I have 100 slides, but I can knock it down to 50 if that helps. Yeah, I'll go quickly. First, thanks to AEI. Yeah, on the bottom. Thanks to AEI for holding this important event, and I'd like to, I think your comments on Chairman Goodlatte are accurate. I mean, he was spot on in his remarks today, and it is heartening to see bipartisan compromise and seeing bicameral support for an issue and something that the White House has talked about as well. And so maybe this is something that we can get signed into law this Congress that will help businesses throughout our country. Patent trolls and patent system in general is an issue I think that most Americans don't think about. I think when you probably mention patents or patent trolls, people's eyes glaze over, and it's an issue that most people don't understand how it impacts them on a daily basis, and most businesses don't maybe think about how this is going to hurt their business. And so we worked over the summer on an advertising campaign in targeted states talking about how businesses need to talk about their issues with patent trolls and how they've been targeted in suits, because I think a lot of businesses throughout the country and on Main Street America have been targeted in patent cases, but just have been suffering silently and not talking about this issue. And I think what we've seen from some of the data from Professor Besson and what Chairman Goodlatte touched on, this used to be maybe just an internet and tech problem a few years ago, but as it expanded into an issue that is impacting virtually every kind of business across the country. And what's interesting about this ad is not the scary-looking cartoon troll, though that might be interesting to you. It's in the bottom right-hand corner, the partners that have been working on this issue, and Chairman Goodlatte alluded to this as well, where a few years ago it was mostly tech companies that cared about patents. Today, it's grocery stores, it's restaurants, it's retail shops, it's also hospitals and banks. Virtually every kind of business you think about throughout our economy has been impacted by this, and they're all interested. And that's why when Chairman Goodlatte was talking about the coalition that's built and asked for relief to this program has really, really grown. And I think that's why going to be a big part why we will see something signed into law, because it's been a huge drain on our economy and has been very harmful to our economy. Some stats have pointed to over the last 20 years, $500 billion in costs because of non-practicing entities and patent trolls. Over the last 4 years, the costs have reached $320 billion, and studies have shown that actually in 2011, that number reached $80 billion with $29 billion in direct payouts. So this is money that is coming out of our economy and coming out of all kinds of businesses that could otherwise be spent on job creation, be spent on innovation and products, and during difficult economic times, I don't think we want to see $80 billion a year going out of the economy. Professor Besson talked about actually some of these numbers as well. 82% of the businesses targeted have revenues under $100 million, so primarily it's a small and medium-sized business issue. Speaking of the types of patents, there were questions about this for Chairman Goodlatte, and I'll get into it in a bit. On the business method patents, they're litigated 9 times more than any other patent, so that's clearly an issue within the system that, like Professor Besson was showing, that certain patents get litigated much less, and these are patents that 9 times more than any other, and so that's an issue. And again, the abuse is on the rise. Since 2006, non-practicing entities and patent trolls only accounted for 20% of the total litigation. Last year, that has jumped to 62%. And the reason for this is that there's little upfront cost for these entities, there's little downside for these entities, and it has become a very lucrative business where you can extract very large settlements before you even get to the litigation process. I'm giving some more examples, and Chairman Goodlatte did talk about this a little bit, some examples of what is a business method patent. These are largely things that happen maybe in the brick and mortar economy, then someone has patented the idea of doing it online. For example, sending shipment confirmation emails to customers and tracking location of the vehicles is not necessarily novel or an original idea, but this is an actual patent that has been used to target many retailers, airlines, and even public transportation agencies. And when these kinds of entities are paying out settlements on an overly broad patent that probably many of us would argue shouldn't have been given out in the first place, those costs get passed on. Another one, allowing customers to select seats and reserve seats on your flights or buses or other things. Again, this is targeting airlines and other industries that many years ago you wouldn't think would be brought into patents. And another final example, having on a website where you can order meals or view menus or nutrition information. So if you walk into McDonald's and you see on the side wall they have, how many calories in your Big Mac, that's fine, but when McDonald's puts that on their website, they're subject to a patent troll suit. And there are a lot of businesses that have been hit by this, many restaurants, grocery stores, and everything else. And on these types of patents, on these business method patents, when they do go to court, 85% of the time the patent trolls lose because the patents are overly broad. They shouldn't have been given out in the first place. But that does come at a great cost. Many businesses cannot afford to go through the very costly litigation process. And part of the business model for the patent troll entities is to offer a settlement that's going to be a fraction of the cost of what you're going to go to court on. And when we look at some of the legislative solutions that Chairman Goodlatte has in his bill, and it's a bipartisan bill, it helps to level the playing field, because the way the system is working now, you're a business and you're getting a letter saying, pay us $1 million, and you talk to your attorney and they say, well, to win in court, it's going to cost you $2 million. And it's not much of a decision for a company to decide to settle, even though they know they're right and they would win in court, because the amount of money is a lot higher. Speaking more about the covered business method program, some myths I'll just quickly go through. Some folks are saying that the legislation would cover technological inventions, but in fact the program only covers business method, and the Patent Office does have different definitions and standards for what a technological patent is versus a business method patent, and it's not the intent of the current program or an expansion of that program to include other patents that are outside of these business methods from these examples that Chairman Goodlatte gave and I just outlined. Expanding the program would give a special standard, and I think actually there was a question for the Chairman earlier on that. In fact, the patentability standards stay the same, and that's not changed at all. The only difference is it provides a response to litigation. So instead of going through the costly litigation process on these patents, only when somebody is sued, it goes back to the Patent Office, and if the Patent Office decides that there's a suit and they deem that more likely than not this patent should not have been given out in the first place, then it goes under review. But there's not a different standard on the patentability. The program is new and rarely used. In fact, what we've seen in the financial services industry where this program is being used, it has reduced the number of suits and has discouraged trolls from going in that area. And so in fact that's an argument that we should expand the program to help the rest of the businesses in the economy. And lastly, expanding the program would harm innovation and hurt the patent system. In fact, we would argue the opposite, and Chairman Goodlatte did as well, that by weeding out the bad patents, by weeding out patents that were maybe mistakenly given out or too broad or being abused, you in fact strengthen the entire system by making sure that only the high quality patents, and most of the patents are high quality patents, are the ones remaining in the system. And here's some of the legislative fixes actually that are in, some of them are in Chairman Goodlatte's bill and other bills. I don't necessarily have to go through all of them. Chairman Goodlatte, I think, talked about each one, but I will point out that all of these are bipartisan. Both Chairman Goodlatte in the House and Chairman Leahy in the Senate have talked about addressing these problems. And leading Republicans in the House like Darrell Issa and leading Republicans in the Senate like John Cornyn have been very vocal. And also on the Democratic side, Chuck Schumer, Senator Schumer from New York, and Judy Chu from California have bills as well. So this is a very bipartisan issue. The Obama administration has done executive orders and called out this issue, as well as the FTC. So across the board, this is something that that can be addressed. And finally, in closing, really the point of this is to strengthen the patent system and weed out abuse. And by doing that, you do strengthen innovation and you help the economy. And really, we think this is a win-win. And that's slide 100. Thank you.
Great. Thank you.